Welcome to another episode in the Law Report. This is episode 37. Today we are going to discuss how long or the duration in which the police could detain a suspect without charge. This is known as pre-charge detention. But before I do so, my usual disclaimer: this is not legal advice, should not be construed as such, and for legal advice, please contact a competent lawyer of your choice. I'll be back to discuss the matter shortly. In the Turks and Caicos Islands, the police can hold or detain a suspect up to 48 hours before charge. If not charged, the police must release that person either on bail to return at a later date to the police station or completely discharge that person. However, depending on the nature of the offense that they are investigating, the police can apply to the court to hold a person up to 14 days in the first instance and a further 14 days in the second instance, a total of 28 days without charge. Now, it is important to note that this could only be done on the orders of the court. Many times, this is done where the police are investigating firearm related offences, but the law also confers powers on the police to apply to the court to hold a person pending charge in custody longer than 48 hours for other offences. Now, this is set out in the Firearm Related Offences, Detention and Bail Ordinance. Section 3 of the ordinance sets out detention without charge, and section 3.1 states, notwithstanding any law to the contrary, a police officer may, without warrant, detain for a period not exceeding 48 hours a person whom he reasonably suspects of committing or having committed an offense listed in the schedule without charging him for an offense, and such a person is not entitled to be granted bail during that period of detention. So, in the first instance, in order to lawfully detain a suspect, the police must have reasonable grounds for suspecting that he have committed an offense, but this will be subject of another episode. Now let's look at the offenses in the schedule referred to by section 3.1 of the Firearm Related Offences, Detention and Bail Ordinance. Offenses in the schedule are A. Possession of firearm or imitation firearm with intent to commit a serious offense or with intent to resist or prevent the lawful arrest or detention of himself or another, or intend to put another person in fear. B. Shooting or wounding with intent to do grievous bodily harm, inflicting bodily injury with a weapon. C. Robbery, aggravated burglary, assault with intent to rob. D. Burglary in a dwelling house, if any person in the dwelling house was subject to violence or to the threat of violence. Assault causing actual bodily harm. Possession and or use of firearm ammunition with intent to endanger life or cause injury to property. Possession of the firearm or ammunition without a license, certificate, or permit, contrary to the provisions of the Firearms Ordinance. H. Sexual assault. I. An offence involving the possession or use of a weapon of offence. J. A criminal act involving a firearm. So those are the listed offences that is set out in the schedule that empowers a police officer to apply to a court for an order of detention beyond 48 hours. Now let's look at section 4 of the ordinance. Section 4 states, and section 4.1 specifically, that within the initial 48 hours of detention, a police officer of at least the rank of superintendent may apply to the court for a warrant for further detention. So, in my respectful view, the application must be done before the 48 hours expire. So the police must make an application within a timely manner. And it is my respectful view that if an application is made after, the court should or ought to refuse to hear the application, because that person would not be in lawful detention. Those are my views. Further guidance is set out in the section as to the procedure and the burden the police have to meet in order to persuade the court to grant the warrant of further detention. The court has a discretion according to the evidence set out in the affidavit to grant the full 14 days or any amount of days it sees fit, but the court cannot exceed the 14 days. However, before the expiration of the time granted by the court, so let's say that the court grant 10 days, 7 days, or the maximum 14 days. Before that period expires, the police officer may make an application to the court for further detention. And section 5 of the ordinance deals with this. Section 5.1 says, on an application, an oath made by a police officer of at least the rank of superintendent and supported by an affidavit, the court may extend the warrant of detention issued under Section 4 if it is satisfied that there are reasonable grounds for believing that for the detention of the person whom the application relates is justified. Again, in an application for extension of detention, the court has a discretion to award or to grant a period of time that it sees fit, having regard to the evidence produced to the court by way of the sworn affidavit. However, by virtue of Section 5.2 of the ordinance, the period of extension, together with the original period of detention granted under Section 4, shall not exceed a total of 28 days. So, when the court grants an order for detention, the court ought to be mindful that it does not exceed in total 28 days. So if a false application is made and the court grants a specific time, and a second application is made for full detention and the court grants a specific time, the court ought to be mindful that the time that it grants does not exceed 28 days in total. So in essence, a person could be held in custody for 28 days by court order without charge. On expiration of the period of detention, the person should either be charged or promptly released from custody. So if at the time the period of detention expires, there is no evidence to charge that person, then that person should be released. And if there is evidence, then the person should be charged, but the police then have no authority to continue to hold the person beyond the time granted by the court. If the application is refused, because the judge also has a discretion to refuse the application for detention, having looked at the evidence, the circumstances, and all the facts produced by the police. So if this application is refused, that person should be immediately be charged if there is evidence, or the person should be released on bail or without bail. Having released that person without bail, the police do not have the authority to rearrest the person while investigating the same matter unless new information comes to light. So they cannot go back on the same old information that they would have had previously and rearrest that person. There must be new information coming to light. So there you have it, viewers, in the Turks and Caicos Islands, for offences not mentioned in the schedule under the Firearm Related Detention and Bail Ordinance. The police can only hold a person for 48 hours without charge. For the offences mentioned in the schedule, the police can hold a person for up to 28 days, but this must be on the orders of the court. And yes, in the Turks and Caicos, there are persons who have been held in custody without charge on the orders of the court for a lengthy period of time, but according to my knowledge, not exceeding the 28 days specified in the ordinance. And there you have it. Here is where I will leave it for today. Thank you for watching, and I will see you in another episode.